staying on this channel, Law School Made Easy, at Law School Made Easy 256. We want to thank you for the subscriptions, for the sharing and liking of our videos. We really appreciate. Let's continue the interactions in our comment sections such that we grow as a team, we grow as a family. Today we want to go straight into contract, and we want to look at the privity doctrine, the doctrine of privity that clearly suggests, and we want to straight enter into it, that we all know the general rule of the privity, that you cannot sue to a contract where you were not a party. That the only people who can sue on a contract is somebody who contracted. Let's take an example. If it is between Matalo and Jerry, if they sign a contract, let's say to sell land, so me, Walter, I cannot sue on that contract because I was not a party. So that is the general rule, that you cannot sue on a contract where you were not a party or a beneficiary. Now, to give a very clear picture, let's look at the case of Dunlop versus Selfridge. In this case, there was a contract between Dunlop and Dew Company, where Dunlop sold tires to Dew Company and told them never to sell below a certain price, not to go below a certain price. However, Dew Company also sold the tires to Selfridge, and Selfridge had to sell the tire on a different price, which Dunlop had not agreed with the Dew Company. Now, Dunlop went to sue Selfridge for violating the contract. However, court held that Dunlop his case would not succeed because he was not party to a contract between Dew and Selfridge. Therefore, he could not sue simply because he was not a party. So that is the general rule. Take it as plain that only the parties who enter into a contract are the only that can sue on that contract, that have access to that contract. However, we know that in contract or in the law, we have exceptions to every general rule. Every general rule has an exception. And in this case, we have exceptions to the privity of to a doctrine privity. We have exceptions to it. Number one, in the exceptions we say that a third party can sue on a contract even when they were not party to it, but for as long as it confers a benefit on that person, then you can freely sue on that contract. Let's take an example. Let's have these points. Point number one, we can take the position of the act, the position of the law, or the position of the Contracts Act. In the Contracts Act section 65, it clearly says that someone can sue, somebody who was not party to a contract can sue if that person is a beneficiary. 65.1. If that person is a beneficiary to that contract, then you can sue on it. They further say, if that person, if the framers or the makers of this contract suggests that their contract should be implemented by a third party, then that third party can do what? Can sue on a contract where they were not party. Let's take it more slowly. We are saying that the position of the act as point number one, that you can sue on the contract simply because the act, the Contracts Act, or the law has given you the mandate. Number one, if the contract confers a benefit on you, that in this contract so and so benefits, so meaning that that so and so who has been given opportunity to benefit the contract can sue on it. Number two, if on proper construction the parties wanted the contract to be sued by a third party, so if on their construction of the contract they want it to be implemented by a third party, then that party can also be part of the contract. Let's go into another point. We can now look at negligence, maybe. Let's enter into negligence. You find that we shall straight enter into a tort. We enter into negligence, into a case of Donoghue versus Stevenson. In Donoghue versus Stevenson, Donoghue sued the manufacturer of the wine that he had bought from a wholesaler. Donoghue went and bought a wine from a shop, and that wine had a snail in it, that when he took the wine, it upset his stomach, and he went and sued. He never sued the person where he bought. Donoghue sued the manufacturer, and in court it was held clearly that a manufacturer had a duty of care on the last consumer. Therefore, the mistakes made by the last party could not exonerate them. Because me, the consumer, Donoghue, I bought this from a wholesaler who also had bought from the manufacturer. So, and the mistake, the snail must have been packed at the level of the manufacturer. And now the court's holding was that the manufacturer, Mr. Stevenson, had a duty of care on the consumer. Therefore, that is why Donoghue succeeded in suing the manufacturer. So that is how you come now to be part. A third party now can sue. In this case, the contract was between Donoghue and the wholesaler. But you see, Donoghue is reporting Stevenson, who is a manufacturer. So just because of the principle of duty of care. So in terms of negligence, then some other party which was not part of the contract can sue or can be liable of the mistakes made, because manufacturers owed a duty of care to us, the consumers. Let's go to another point. This could be the bills of exchange. Now, in the bills of exchange, this is more of a bank business like checks. For example, issuing of check. If I issue, for example, myself, Walter, I go to the bank, my bank, for example, I open up an account with them. I even go ahead and request for a check. Now, the contract or the bank account I have opened, it is strictly between me and that bank X. In this case, our channel is still growing. We can mention any name of the bank, but later when we grow, they would have to give us money. Let's take Diamond Trust Bank, where I have my accounts now. If I open up an account for Diamond Trust Bank, the contract is between Walter and Diamond Trust Bank. I even go ahead, I apply for a check leaf, and I am given a check leaf. Now, in my transaction, as day to day, I write a check to Mr. Jerry Sanya. I give Jerry Sanya a check that you go and you are paid this amount of money. Now, Jerry goes to Diamond Trust Bank and banks the check, and then the money is not given to Jerry. Maybe there are reasons. Maybe I didn't have money on my account. Now, Jerry, a third party, can sue on this contract. Remember, he was not there when Walter and the bank were making their contract. But I've only issued a check, and the bank has declined to pay. So the rule is that Jerry has all the rights and obligation to sue on this contract, simply because for him, he must have offered a service and he needs to be paid. But on our contract, he was not party. So the general rule is that a third party can sue on a contract where they were not party to that contract, or where they were not privy to that contract. Let's look at another point. We can take the third party insurance. Let's try the third party insurance now. We have all moved, most of us, of course, we have all moved in taxis at one time. I remember as a person, I have moved in a taxi, Some of you are watching have owned a car, but you see on the car, you have something third-party insurance. You go and buy a third-party insurance. Now, the owner of the car and the company of insurance enter into a contract that if I get a problem, if I get a challenge, an accident, the insurance will cover up me. So they enter, the owner of the car enters into a contract with the insurance company. Now, the other person, let's say Alpha, who is not the owner of the car, is not part of the insurance, uses this car and say gets an accident or gets a problem. The question is, can he successfully sue? Yes, on the exceptions to the contract. That person who was not part of the contract between the insurance company and the owner of the car can successfully sue on this contract. We can think of another one. Maybe let's discuss something we call assignments. Another point would be assignments. What do we mean by assignment? Let's take an example for our easy understanding. This is law school made easy. We want to make these things in the possible, to make them easy in a possible way, such that we can understand this concept. So that's why I'm giving these examples. Let's handle the term assignment. We are saying that if I am, let's say, the boss, I assign Simon Peter to construct for me a flat, a home or a flat. So we agree that this flat will cost 1 billion shillings. I get 600 million, I give them to Simon Peter for him to construct and take on the building. Now, Simon Peter starts to build and he runs out of money. Remember, I have is 400 million. Maybe I do not have money at that time. Now, Simon goes, remember I gave him the powers to construct this house for me at 1 billion shillings. Is now demanding 400 millions. Now Simon goes and asks Jerry. You know, I keep on talking to Jerry. Jerry is our cameraman here. So he goes and asks Jerry that, Jerry, lend me 400 million. I complete this housing, or you go and complete this housing. My balance is 400 million. Now, Jerry has gotten the mandate from Simon, and now either Jerry gives Simon the 400 or Jerry comes and completes the building. Now, Jerry can now sue on the contract which we entered between me, myself, and Simon Peter. In more so, Simon Peter has passed on powers of attorney to Jerry to complete that building. He has assigned Jerry to carry on with that work. The work which initially was meant for him. So Jerry, on breach, if I do not pay that balance, so Jerry can now sue for his money and Jerry would be successful. But remember, Jerry is a third party who has come into our contract. Remember what we are discussing. They are the exceptions to the general rule. Let us now discuss something we call trust. Trust. That on construction of a contract, a trustee can sue on that contract and the beneficiary can sue on a contract. Let's take a clear example here. What we mean by trust. If Jerry signs a contract with Simon Peter Matalo, and Jerry tells Simon that this contract, if my children grow this land, you transfer this land to them. And Jerry trusts Walter with this agreement, telling him that when my children grow, you go to Simon Peter Matalo and you pick the title for my children. Now, Walter becomes a trustee. Now, me as a trustee, if Simon doesn't bring, if he bleaches or he doesn't bring the title of the children when the children grow, then me, the trustee, I can sue on the contract which I was not part of. It was not, I was not there when Jerry, my father or my friend, was making a contract with Simon. I'm just a trustee. So a trustee can sue on a contract. In their skill, a beneficiary, the children are the beneficiaries. There is a benefit in the contract made between Jerry and Simon for the children who are still young. Now, when the children reach the age of maturity and they want to get their property where they have a benefit, so the children can sue on a contract where they were not party, but the contract only conferred a benefit on them. I urge every person to read section 65, 1A and B and 2A. It clearly explains that where there is a benefit conferred on you in the contract, you can come and sue, even when you were not there at the time when a contract was being made. So those are some of the exceptions or areas that a third party can sue. And we have agreed, number one, that we have the position of the act as point number one, we have trusts as point number two, we have negligence as point number three, bills of exchange as point number four, third party insurance as point number five, and assignments as point number six. So we thank you so much for watching this channel, but we urge you to read the book of Professor Ben about the exceptions of the doctrine. Professor Benz clearly brings out these concepts with cases, and you appreciate them so much. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Thank you so much. Subscribe, share, and like our videos. Thank you.